Now, we're going to talk about a different type of misdemeanor proceeding now that I did not cover in the last video, and that's because the procedure is different, faster, and unique. And this is what's known as the Violation of Probation or House Arrest Docket. In misdemeanor court, you do not have sentences which will have community control. That's a form of house arrest that's done in felony court only. In some counties, and not all, you have house arrest through electronic monitor. More commonly, you have probation without that. And so with probation procedure, the first thing that happens is the probation officer files an affidavit of violation. This is a sworn document where they list out every single ground they believe that constitutes a violation of probation. Now this is where you can get ambushed. How do I mean you can get ambushed? Well, you get ambushed because I'll ask somebody, why do you think you're being violated? And they'll say, I'm being violated for this one thing. Well, then we get an affidavit of violation, court costs are unpaid, behind on cost of supervision, is a laundry list of several things. And a person might say, but I still have time to complete all those things. Trust me, if a probation officer can list additional things, they're going to list everything they possibly can, because the more they list, the easier it is for the state to get a conviction if it goes to a contested hearing, which we'll come to in a few minutes. So to begin with, you have an affidavit of violation. You have what's known as a violation report form, where the probation officer goes into more detail and background about the history of supervision, what's been paid, what's owed, etc. And that's a separate document from an affidavit of violation. Now, from there, what's going to happen is it goes to the judge for an arrest warrant. The judge, if the judge finds there are legal grounds, and usually they do, an arrest warrant is then signed. Now, the arrest warrant may have a bond amount, but because there's not a right to a bond in a violation of probation, quite often, and in some counties, always, you never have a bond on a violation of probation. Now, if that's the case, it might be appropriate to do a motion to set bond. And the time to do a motion to set bond may or may not be at a proceeding we've talked about in another video, and that is first appearance. When someone is taken into custody in a misdemeanor case and they do not have a bond, what will happen is they will have a first appearance. When the judge is looking at the paperwork and deciding probable cause, well, that's easy. Probable cause exists because a judge has signed a warrant. This is where it gets tricky. If the judge who signed the warrant, the trial judge on your original case, is the judge at first appearance, then the judge will entertain a bond motion. Does that mean the judge will grant it? No. It means the judge might grant it. Now, if the judge is not the trial judge of the case, 99% of the time the answer is going to be no. I can't hear a bond motion. This is not my case. And so in that case, we have to do a motion to set bond, if that is the appropriate thing to do, and it's not in every case, at a subsequent hearing. However, in some counties, judges in misdemeanor divisions will set bonds for each other. Now, it's unusual. It's not very common. We do have a county where that happens in the First Judicial Circuit, and others exist across the other 19 circuits in Florida. So it's critically important, if you believe you're going to be violated, or if you have a family member who has a warrant active and you're calling on their behalf, notify us and hire counsel quickly, because if we can get them a bond, by all means, we want to be at first appearance and get them a bond. If we cannot get them a bond and a bond is appropriate, then we want to go ahead and file that pleading and get the earliest possible court date. So that's a little bit about misdemeanor VOP procedure. Now, you still have motion hearings that are possible for bond, for evidence matters, dismissal, suppression, all kinds of things. But the burden of proof in a violation of probation is the greater weight of the evidence. And you can mentally think of this as 51%, as opposed to beyond and to the exclusion of every reasonable doubt. You can think of that as 97, 98, 99%. So there's a massive difference in the burden of proof. Procedurally, after first appearance, there is something known as violation of probation arraignment. Now, basically what that means for a defendant who's in jail is they get carted off to the courthouse. And if you're in a place like Lake County, basically walking across the overwalk that's secure while being chained up and going to court. That's bad, but it's not nearly as bad as being awakened at the crack of early in Crestview, for example, and driven tens of miles to the courthouse in Fort Walton Beach. I mean, that's a pretty good hike to be, chained to a bus. And if you're in Defeniak Springs, so that's where your court is, and someone's being held in the jail there, that's not quite as long a drive, but it's still a long enough drive and uncomfortable. So sometimes we will waive arraignment in a misdemeanor VOP case because nothing useful is going to happen. We're trying to work out a settlement, we're investigating defenses, whatever. But for whatever reason, we don't need our client tremendously inconvenienced while they're in jail, or if they're out on bond, to go to a pointless court appearance where nothing useful is going to occur. Generally speaking, if you have court, we want something useful to happen so that you're not inconvenienced in any way, shape, form, or fashion. Because we understand court is stressful, and we want to minimize that as much as possible. Next, if you have a violation of probation and arraignment has been waived or not, then you could also have a violation of probation evidentiary hearing scheduled. What is a VOPE? Violation of probation evidentiary. That is like a trial. There's some key differences. One, the burden of proof is lower. Two, a judge instead of a jury makes the determination. Three, if there are 6 grounds in the affidavit of violation, they don't have to prove all 6. They just have to prove 1. So you have a lower burden of proof, sometimes a scattergun affidavit of violation, and sometimes these are difficult cases to settle. So we'll keep in contact with you, but those are the proceedings, and I want to tell you a little trick that we have to close this segment out. Let's say, for example, that somebody has a case and it's scheduled for arraignment in 6 weeks. We have a deal cut within a few days of representation with the prosecutor that does not involve jail time. Yet there we are with a client who's stuck in jail. Well, there are a couple things we can do since it's a misdemeanor case. One, we can use a written sentencing agreement to where the client does not have to be present because it's a misdemeanor case. Now, certain I's have to be dotted, T's have to be crossed, and to put it bluntly, it has to be done perfectly correct. Okay? We have a lot of experience doing that, so we know how to do it. And that avoids court entirely. We can get the order to the judge as fast as possible. And a lot of that's out of our control. But for that which is in our control, if you're sitting in jail or your loved one is sitting in jail, which is more likely the case if you're watching this, then we want to get that person out as quick as possible if their case settles. 2, another way to do it, let's say that we have a capped agreement where the state wants 30, 60, 90 days in jail. We want none. Well, the state agrees to ask for no more than that. That's known as a cap. Well, in that case, we do a motion to set bond fully knowing that all it's going to do is that court date that's 6 weeks out, it's going to bring it forward by several weeks. We then use the bond hearing to withdraw the bond motion. We ora tennis, which is a fancy way of saying orally, make a motion where violation of probation is admitted, a plea colloquy ensues where the judge will ask the defendant questions, and then if the plea is knowingly and voluntarily entered, then we submit argument in a particular way. Now, if we're successful, this prevents many weeks elapsing between the time the person enters the admission and sentencing, because if we're successful, we don't want to get this great outcome but have to wait many, many weeks while someone's sitting in jail that they don't need to sit in if we're going to be successful in that hearing. So that way we can speed the process up. So we have a number of little tricks and procedures that really, they're not tricks so much as they are things you learn from experience, because a lawyer with experience is never at the mercy of a lawyer with nothing more than a hypothesis or an empty theory. So we use that experience to move court dates around for you. Finally, there could be a full-blown sentencing hearing as a result of a violation of probation. We might have to enter an admission on one day and do a sentencing hearing later on down the road. Those things do happen in violation of probation cases. Finally, there may be other things as well that are specific and unique to your case, and if that is the case in your case, we will let you know.